strings. So we were going to Hedikar.
My lord, yes.
Paragraph 13.
Yes.
Yes.
And it is, in my submission, the proposition that it's court responsibility to look at jurisdiction and court's responsibility to apply the regulation, whether or not it is as pleaded in terms of jurisdiction in the petition. And
this was directed to the jurisdiction provision in Brussels 2A.
yes.
Yep.
And in particular, where, forgive me, where a petitioner had either failed to tick all of the boxes or failed to tick the right box, whether that required formal amendment and the discretion to refuse the amendment, or whether in any event, if the court was satisfied that an additional jurisdictional ground was made out, that of itself sufficed.
Thank you. Yes.
And, excuse me, I'm so sorry. And we say by parity of reasoning, the court in the present case was not a mere observer of the proceedings as to what was happening between the parties. We invite your lordships to say, in accordance with Rogers Hedikar, there is an independent function, independent responsibility on the court, and whilst I entirely accept or perhaps anticipate that your lordships may be reluctant to say that the English court is required to do something if nobody asks it to do so, nevertheless, in the logic of Rogers Hedikar, the position of the English court, just as of any other court, is considerably more proactive than reactive.
How is the English court to know if the jurisdiction of the foreign court has been established?
Well, my lord, in this particular case, by the order of the 18th of May 2017.
When was that first put before the English court?
I think I'm right, and forgive me, I better take just a moment to give your lordship a definite answer rather than what I'm thinking. Lord, thank you. I'm sorry for the time that's taken. The end answer to the question, when was it clear in England, is that the wife's application to lift the stay
Yes.
was dated the 19th of February 2019. and that was the application that ultimately Her Honour Judge Roberts was determining, not least because His Honour Judge Everall hadn't determined it, but she was determining that application, and the application to lift the stay was supported by a statement which made the concession.
Right, so at some point in the... sorry, I can't... first of all, again, obviously speaking for myself, there is a difference between the situation that Lord Justice Thorpe was referring to in Hedicott, which is whether the court does or does not have jurisdiction. Because the court doesn't have jurisdiction. So if a judge, when proceedings are started, is concerned as to whether he or she has jurisdiction to make the order, then of course the judge has to raise it. Because if he doesn't, he doesn't.
Yes.
With respect, I think Article 19 is a different situation because it's not a matter of whether the court has jurisdiction, it's whether the court should exercise any jurisdiction it has or should stay or dismiss proceedings. It's not the same situation. And the point is that when a petition is filed, if, for example, a fact was alleged which didn't give the court any jurisdiction at all, and it's more difficult now with tick box, but in the old days that wouldn't be possible, the judge would have to say, would be required to say, I'm not sure this vests jurisdiction in the court. That's why in all public law child proceedings, first thing the court has to determine is whether the court has jurisdiction, and if so, under what factual situation, usually habitual residence. So that's why I think we're asking, when did this, how was the court to know, what was in front of the court, when, and do you see we're going down an investigative process which might introduce adversarial issues, such as, have the proceedings come to an end? Is the order being appealed? I mean, all sorts of... So it's... Anyway, that's why we're asking, when did the court have the order? And as I said, I know there was an issue as to the translation of the order, but it was being advanced on the basis of jurisdiction is established, but not... Anyway, so... Sorry, I'm slightly rambling, but thank you.
Well, my Lord, I come back to the Italian order of the 18th of May 2017.
Which was provided to the court sometime after February 2019, and that should have led to the court saying, hold on here, we should be dismissing these proceedings.
My Lord, yes, your Lordship may recall the passages in His Honour Judge Everall transcript that dealt with exactly that topic, and in the statement in support of the wife's application to lift the stay, which she made in February 2019, at the latest it was accepted then that the Italian proceedings were established as to jurisdiction, and at that stage there was then a debate as to whether, on the wife's case, the jurisdiction of the Italian court was in some way limited to 12 months. But that was a debate on the wife's case, which then changed when the Italian court pronounced the judicial separation decree. And so we say, with respect, that the significance of Rogers Hedikar in the present case, and I entirely accept the distinction that your lordship, my lord, or Justice Moylan, makes in relation to Rogers Hedikar as against the present case. But what Rogers Hedikar points to in our submission is the responsibility on the court, in this case the English court, to apply the firm framework of the relevant regulation. So it is a generic responsibility, not just a responsibility in relation to Article 19.3. And if the court is against me that the court has that responsibility even if nobody draws it to the court's attention, then with respect, my fallback, of course, is to say, yes, but it had been drawn to the court's attention very firmly and indeed repeatedly. And in the passages that your lordship invited me to take the court to this morning, and which I went through and perhaps went through too slowly, there's one passage that in the exchange of question and answer I probably, indeed I did, fail to draw to your lordship's attention. So if I may, I'm going to take that one omission. And it is that if
Page.
your lordships go to the supplemental bundle at 212, in the skeleton argument that the husband submitted to His Honour Judge Everall, and I'm going to come on to where it connects with Her Honour Judge Roberts, but in the
August 2019.
My Lord, yes, I'm very grateful. Paragraph 24. Once this is at 212 in the supplemental bundle. Once the jurisdiction of the courts of Italy was established, it's respectfully submitted that the Central Family Court should not only have stayed the wife's petition, but should decline jurisdiction in favour of the Italian court pursuant to Brussels 2A, Article 19.3.
Sorry, which page are you on?
212, my Lord, of the supplemental bundle, paper 212.
Paragraph
24.
Yeah.
Under the heading Summary of the Submissions on behalf of the husband.
Alternatively, 25.
My Lord, yes. Because
At the risk of trying your patience and my lord's, can I go back to one of the passages that you did refer to, following on from that? If you go on to back to 114, this is the hearing before Judge Everall following that submission, I think. It's a hearing following. It's the 2nd of December 2019. So it comes after the document we've just looked at. It may not be the first hearing, I've not got the chronology here, but you're on the transcript of the 2nd of December 2019. So
yes.
After the document.
Internal page 37.
Yeah, 40. Internal page 40.
Sorry.
We looked at it this morning. And this was the exchange between the judge and Mr. Lazarus. And the judge says halfway up the page, you can't just leave it with the petition, as it were, being declined by the English court without anybody making an order. I think there needs to be an order. Got that?
Yes.
Then further exchange. And the judge, further down, I can see you could read it saying, well, in fact, I don't need to lift the stage to apply to dismiss the petition, just apply to dismiss the petition, and it would probably be done by consent. Mr. Lazarus, well, the English court should have declined jurisdiction because Article 19.3 requires it. Judge, yes. Mr. Lazarus, but that doesn't lead to an automatic dismissal of the petition. Judge, yes. And I invite you to conclude the proceedings are stayed because that is what both parties understood and the judge indicated. Now, what was the judge supposed to do in the light of that exchange?
Lord, I'm going to come on, obviously, to the difference between His Honour Judge Everall at that hearing and the order of Her Honour Judge Roberts, which is under appeal. But in answer to your lordship's direct question, this is not an appeal against His Honour Judge Everell, clearly.
Well, it sort of is, because you want to go back in time. The trouble is that you, in relation to Judge Roberts, you say effectively she should have done what she was asked to do by reference to submissions in relation to the position before, whatever the relevant date is, October 2019. And yet here it is all being debated, and it doesn't look as if that is what is being asked for. So assume you're right, and that there is some obligation on the part of the court. In the light of that exchange, would the court say, well, yes, it should be, I won't do that, instead I'll decline jurisdiction, even though that's not what's sought by anybody? It seems to me there's a sort of lack of realism about that.
My lord, there's a particular contextual answer that I need to give, which I can anticipate is clearly going to be unsatisfactory. But as my learned junior knows because he was present, this particular exchange that we're considering was at the end of an argument raised by His Honour Judge Everell.
Yeah.
That the petition itself was no longer stayed by reason of the particular words that had been used in relation to the English order that stayed the petition in the first place.
So in other words, and I hope Mr. Lazarus doesn't think we're being critical of him, because this is obviously a very tricky area. But we need to look way back, read the whole of the exchange, not just the little passage I drew to your attention.
With respect, yes, and one inevitably comes to in the context of the transcript of the hearings before the hearing that we have the transcript for in front of His Honour Judge Everell, there are inevitably or otherwise semantic exchanges which your lordships may not find readily of assistance.
I mean, it just looks to me as though, at this point, there was agreement between judge and counsel that it did require a positive act by the court, and it wasn't an automatic dismissal of the petition. That's the phrase that Mr. Lazarus uses. Anyway, we better read the whole thing.
My lord, I'm sorry to say yes, but the point that follows it with respect is the closing submission, the written closing submission to Her Honour Judge Roberts, Judge below, from the wife's counsel, Miss Jackson. That closing submission is in your lordship's supplemental bundle at 325 and makes it absolutely clear that no one was in any doubt, or could be in any doubt, as to what the husband was asking the court to do at all stages, namely dismiss the petition. And that is, as one sees on page 325 of the supplemental bundle at paragraph 9 in the written closing submissions on behalf of the wife submitted to Her Honour Judge Roberts. Okay. They were dated the 4th of December of 2020, and as Judge Roberts has said in her judgment, clearly she didn't get to hear either side give their submissions, and that's one of the difficulties that she enumerated. But what the wife's counsel said on that occasion in those closing submissions, paragraph 9 on page 325, it was part of H's case throughout the 5 days before His Honour Judge Everell, QC, that W's petition ought to be dismissed. This was made clear in the position statement prepared by Mr. Lazarus at paragraph 24. And then she says this: Her Honour Judge Everall QC declined to dismiss the wife's petition despite hearing the matter over 5 days on 5th and 6th August 2019. Now, I don't want to get into a semantic debate on this point either, but as your lordships can probably anticipate, it's the question of declined. It's absolutely correct to say that His Honour Judge Everall did not make an order. But it is not correct to say he refused to dismiss the petition. He simply did not determine that issue, and there is no order.
So it has been, jurisdiction had not been declined by the time of the conclusion of the Italian proceedings.
It had not been declined in the way that your lordship is looking for. I absolutely accept there is no order by the English court dismissing the petition. But with respect, we say absolutely clear and centre stage to all parties was that the husband was saying to the English court there should be and should have been a dismissal of the wife's English divorce petition because it was in breach of Article 19.3 not to dismiss it. And that, we say, is the position with which Her Honour Judge Roberts was met in November of 2020, and which she dealt with by not addressing the retrospective breach by the English court of the requirements of Article 19.3. And that, we say, is also relevant to this court's consideration of the Liberato case. And again, I am grateful to my Lord Justice Moylan for...
No, it was... Who was my Lord Justice Baker, not me.
Then in which case I double as well as redirecting.
Are we going to that authority now?
My Lord, yes.
Okay.
Please.
Oh yes, Liberato.
Yes.
The Liberato decision clearly is a reference by the Italian court in relation to a subsequent divorce decree by the Romanian court.
Yes.
And whether the Italian court was required to recognise that or could review and thereby not recognise it. And a very clear answer from the European Court, if I may say so as one might expect, is that you cannot have a review. That is one of the central tenets of the lis pendens framework.
And as set out in the headnote, the Italian court had dismissed the mother's claim for recognition on the basis that the Romanian court's judgment infringed the lis pendens rule.
My Lord, yes, and as your Lord...
And so it's looking at the substantive nature, or that's the wrong way of describing it, the effect on jurisdiction of second proceedings being issued while first proceedings are still current, pending.
My Lord, I would seek to suggest that that it's the distinction, as we would submit, between, on the one hand, recognition, between different member states of orders, and on the other hand, and sorry, pausing there, Liberato says, as we invite your lordships to accept, Liberato says that non-compliance with Article 19 is not a reason to refuse recognition on the ground of a review.
Of failure, yeah. And the same applies even when the court didn't have jurisdiction to make the order. The Court of Justice has decided that you can't question the other court's jurisdiction or exercise of jurisdiction.
And that,
And that was what? Sweden and Latvia, I think, in parental responsibility proceedings. So you're saying that once you get to a judgment and you're debating recognition or enforcement of it, you can't review any prior stage in the process, be it jurisdiction or Article 19.
correct.
Yeah.
And that, with respect, emphasises the distinction between our present case and the Liberato case.
They didn't regard the Romanian proceedings as a nullity.
My lord, indeed, of course I accept that, and it may be that
So we're in a position, what, that if there had then been a full judgment, in our case in the English courts, then that wouldn't be capable of review, so the nullity comes and goes?
well, my lord, no, with respect.
Because if you were right, Romanian proceedings would have been a nullity.
Lord, the distinction that I would draw is between, on the one hand, internal treatment, internal within the courts of this member state, as was, and on the other hand, in Liberato, the external treatment, particularly in relation to recognition of another member state's orders. And we are not faced in the present case with issues of recognition. What we are faced with, and in my submission it is a significant distinction, is looking at how the English court should treat its own failure to comply with Article 19.3.
So you say Liberato should be interpreted narrowly, simply as being an authority on 24, Article 24.
I do, my lord. And it's for that reason that I said, and I acknowledge that my Lord Justice Moylan raised a doubt when I said it, but nevertheless it's for that reason that I said this morning that in our submission, Liberato does not affect the outcome of this appeal, or should not.
It's slightly odd position, because what your submission, the effect of your submission is putting it, changing Romania to England, but maybe the same would be in Romania. In Romania, the order's a nullity. In England, the order's a nullity, but it has to be enforced in Italy. So domestically it's a nullity, but internationally it's not a nullity. I think that rather raises...
My lord, I can see why you...
perplexed.
I can see
Word.
why that formulation perplexes your lordship, if I may say so. The way I would put it is different. It is that the English court has the duty to apply the framework, and it is not for the English court to say, well, in this case we can ignore Article 19.3, which is effectively in the sense of in the result. That is what has happened.
No, but we're talking about the consequences of it, and your submission is the consequence is that the English proceedings are a nullity. And the relevance of this case and of your submission, I think, is that the consequence is that assuming Romanian law was the same on nullity, the fact should be the same, that in Romania the court's order is a nullity, but in Italy it isn't. So that the other party in this case could go to Romania and say, your order's a nullity because you failed to comply with Article 19.
At which point I am back to the primary submission that I make, that in relation to the present case and the Liberato case, there is a meaningful distinction in whether one is talking about recognizing foreign judgments or complying with the framework of the regulation.
Thank you. Yes.
Your Lordships were asking me this morning about the status and knowledge in England of the Italian judicial separation proceedings. I should please draw your attention back to supplemental bundle page 286, in which it was conceded by Sally Jackson counsel for the wife on the 1st of June of 2016 that the judicial separation proceedings in Italy were first in time.
That's not my understanding. There's no dispute about that.
And that being the case, in our submission, from that point onwards, up to and including Her Honour Judge Roberts' judgment, the English court remained under a duty to dismiss the English proceedings. My Lord, final point.
Yes.
The final point, my Lord, relates to the case that I asked should be put on your bench this morning. And I emphasise straight away that it is a point by analogy, not on Article 19 or 19.3, of course. But it is the case of Bada and Caluori, now of considerable authority and age, it is right to say, but it is the analogy point that I seek to make.
Which page?
37, please.
37, got it.
It should be highlighted, forgive me, it's 38, I'm so sorry. Should be highlighted
Yes.
in your Lordship's copies. And it is the point by analogy that if the order that has been made in that case, the county court, is unjust, the right of appeal is to enable decisions to be set right or set aside or varied.
I'm just looking at the clock. We've read that, so thank you. Yes.
I'm very grateful. And
Anything else?
this is the point that this court, therefore, should, notwithstanding the retrospectivity, correct what has happened in relation to this case in Article 19.3. Lord, those are my submissions.
Thank you. Yes. Thank you very much. Mr. McGee.
My Lord, in relation to everything that's been said this morning, a lot of the points and issues that were to be taken on behalf of my client have already been canvassed. But I would like to start by first of all asking the court to turn to the authorities bundle,
Yes.
and actually consider the terms of Article 19.
Right.
Because the point very simply is 19.1 and 19.2 both include the term shall of its own motion.
Yes.
That is omitted from 19.3. And that is a significant point because it's not suggested that that omission was accidental. Because of course, for the court to operate 19.3 and decline jurisdiction, that brings an end, by way of a dismissal, to a petition in this case. And of course, a party should be entitled to be heard on that. And so therefore, there is very good reason why a court should not act of its own motion in relation to Article 19.3. And so the points that have been elaborated on today, and you've heard in relation to actually the court has a positive duty, is undermined by the fact that the term of Article 19 expressly does not include of its own motion. And I say that is a central, important point for the court to bear in mind, having heard the submissions in relation to the duty of the court to inquire and investigate. It is right that in 2016 the issue of jurisdiction was not settled, and that is why, through the orders of the district judges, my client's petition was stayed. It is important to note that in 2016, those stays that were imposed were culminated in the order, the last order of 2016, which is the 27th of July 16, which is important to consider. So I ask the court to turn, please, to the page 25 in the supplementary bundle. And importantly, this order was by consent. Importantly, this order, paragraph 3 on page 25, made it clear to both parties that if either wished to lift the stay that was then imposed, then they were free to apply.
And dismiss the petition.
Absolutely. Crystal clear. What is needed to either dismiss the petition and or lift the stay? An application. Now, it is apparent that in 2017, jurisdiction of the Italian court was accepted by Dr. Carla, the lawyer, on behalf of my client. Well, the very next day, the husband could have applied to the English court to have the petition dismissed because the jurisdiction of Italy had then been accepted. He didn't do that. It is accepted.
What was the date again, you said? Sorry, my...
No, it was, absolutely, my lord. It was, I want to double check to get the date right. 18th of May.
Thank you. Sorry.
Grateful.
Don't take that as gospel. That was just.
No, I checked and it is.
It is. Right.
18th
That
of
was
May,
the- that was the
60.
answer that Mr. Amos.
17. Yes, 18th of May, 17.
18th of May 2017.
Yes.
At that point, the husband could have applied next.
Could have applied, and my client would have had no defence, could not have argued anything other than she wanted the petition to remain stayed. No application was made. The first application that came back to the English courts was my client's application in February 2019, when she was saying to the court, the judicial separation process in Italy has now come to an end, such that I can issue my divorce now in Italy, so I should be able to progress my divorce now in England. And that was the issue that she raised by her application of the 4th of February, prior to the date that she was relying on, when she says that would then apply, and that was the 12th of February 2019. Because there had been a 12-month requirement that the parties live apart, and once that period had expired, then the judicial separation between the parties was complete. And so my client was arguing, because I can now progress my divorce in Italy, I should be able to have that opportunity to progress it in England. And that was the dispute that was to be heard by Judge Everall in August 19. And the dispute that he was considering was whether or not circumstances were such in Italy that it would now allow my client to progress her UK petition. And importantly, we don't have a transcript of that hearing. But what we do have is, on behalf of the husband, we have the note prepared going into that hearing as to what the husband was asking for. And I make it clear, he was not asking in August 19 for my client's petition to be dismissed. And we see that at page 218 in the supplementary bundle. At 218 at paragraph 51, this is the, and 52, this is the outline counsel was submitting Judge Everall should adopt by way of conclusion in August 19.
Sorry, which page?
218 in the supplementary bundle, Mike.
Thank you very much. Yeah.
And where there is talk of dismissal at paragraph 52, it is dismissing my client's application to lift the stay. It's not dismissal of the petition. And that has been a point of dispute between what is asserted when it is said it has always been suggested that the husband has asked for dismissal of the petition. It is quite clear in August 19, going before Judge Everall, it was dismissal of my client's application to lift the stay.
You say that line is inconsistent with the argument that the proceedings had automatically come to an end. Or anything like
Yes, absolutely. At this time, there was a real issue as to whether or not my client was able to issue in England or progress her petition in England, given the cessation of the 12-month period that ended in February 19.
that issue wouldn't arise if the proceedings should have been dismissed, or
No.
if the jurisdiction had lapsed in some way by operation of 19.3?
No, it wouldn't. It wouldn't have. Because before my client's application on the 4th of February 19, had there been an application to dismiss the petition, there'd have been no argument. It couldn't have been resisted.
By this point, the proceedings in Italy had come to an end.
Not by August 19,
Oh, right.
no.
I'm sorry.
Because that's October.
Sorry.
They may have come to an end because my client's application was never fully determined by Judge Everall. My client's application in February was, the proceedings in Italy have completed so far that I can now progress my petition in England. And that was the moot point. But Judge Everall never got to conclude that because between the August 19 hearing and then going back for the adjourned hearing, proceedings were finally concluded in Italy by an indisputable order on the 7th of October 19. So mid the adjourned hearing on the 7th of October 19, Italy made an order which was undeniably conclusive. So then my client's point previously fell away. And at the August hearing, had it been suggested to Judge Everall that Italy is already seized with jurisdiction, it would of course be met by my client saying, but since the 12th of February this year, there has been a change of circumstances and I can now progress a petition there and I should be able to progress a petition here. And that was very much Dr. Carla's evidence that was prepared in relation to my client's application made in 2019. But even if my client's application is regarded as hopeless, regarded as a delaying tactic, regarded in some way as not having any merit, from the 7th of October 19, lis pendens didn't apply because the only existing action or petition was my client's stayed petition in the English court. And that is, of course, A and B. A and B, the wife issued 3 days prior to the actual final order being issued. Lis pendens did apply in A and B for those 3 days.
In this case, it was a much longer period.
Absolutely.
But at no point, is this your case? At no point did the father apply for it to be dismissed.
Absolutely.
On the contrary, he requested the stay to continue.
Absolutely. And indeed, 218, the submissions of counsel on behalf of the husband going into the hearing in August were very clearly not, this court must dismiss the wife's petition. But, of course, the question before the court is whether Judge Roberts fell into error, not Judge Everall. Because even if it is suggested that Judge Everall was wrong by failing to deal with Article 19 point that I say wasn't raised, Judge Roberts was not in error and cannot be found to be in error in terms of the ground particularised which in the core bundle is found at page 13. The error alleged of the learned judge below was that it is, and was in 16, a mandatory requirement of Article 19 that the UK court, it says, shall decline jurisdiction. And therefore, it suggested in declining jurisdiction, that meant it was mandatory for the Central Court to have dismissed the wife's petition in 2016, or at the latest, invitation of counsel at the hearing in August 19. Well, that invitation of counsel is not evidenced. And of course, the point that was being made before Her Honour was that there was no break in time, because on the 8th of October, following the final order on the 7th, the husband did issue his divorce petition. And so the matter before Her Honour in the lower court was in relation to the proceedings continuing to suggest that the court should have dismissed the wife's petition in 2016 is simply wrong. We have looked at the order that was last made in 2016, which made it clear, by consent, to operate Article 19, to consider a dismissal, you have to bring an application. And so the learned judge below, when dealing with the case, is entitled to consider that given there is no appeal of earlier decisions of previous judges, that it wouldn't be right for her to then go back and look over whether or not there was an error by Judge Everell. She was not the appellate court of Judge to consider what Judge Everell said.
Well, Judge Everell didn't say anything in terms of an order.
No order, absolutely.
And you don't appeal bits of transcripts.
But
there was nothing to appeal. Judge Roberts was quite entitled to say, this is all a complete muddle because I've had all of these, I understand there are all these arguments, but nothing arose from them.
My lord, I agree. Had, however, the husband gone before Judge Everell and said, you must dismiss this petition, and then he failed to deal with that in a judgment or an order, that would be an appealable point.
Yeah, well, you'd go back to the judge under the slip rule and say, I asked for this, you haven't done it.
My suggestion and your lordship's answer, neither of those were done. And so, effectively, how on God's green earth can Judge Roberts untangle all that mess? The fact is that on the 7th of October, it is clear the Italian jurisdiction ended. And it is also clear that from the exchanges we see in the December discussion and transcript with Judge Everell, that matters had moved such that my client's original application, which was genuine and was not a sham, simply fell away. It didn't become relevant anymore because we had an uncontroversial date that everybody agreed on, the 7th of October. My client's earlier date of the 12th of February never got resolved. It didn't have to be, because the adjourned proceedings leapfrog the certain date. And so, in looking at how this case does apply correctly A and B, would ask the court to turn in the authorities bundle to page 11, because a very much a nano argument as to how A and B should be restricted to cases that relate to time lapse was advanced. Page 11, paragraph 37 was referred to. But I would ask the court to consider and read again paragraph 37, particularly 38 and 40, because the clear point that is being made by the court is that when the country first seized ceases to have jurisdiction, when those proceedings come to an end, lis pendens falls away. There is no lis pendens issue. Whether it falls away because it lapses, it expires, it's terminated, it's withdrawn, whatever the reason for the country, for the state first seized coming to an end, lis pendens falls away.
Well, your submission would be is that the relevant issue is whether proceedings are pending. How they come to an end is irrelevant, because it's whether they're pending or not, which is the relevant issue.
Absolutely, and in A and B, they remained pending for 3 days from the wife's application, and in this case, I adopt the expression much longer.
Thank you.
Unless there are any other specific matters that the court wished me to elaborate upon, those are the points that I wish to make in addition to those that have already been made.
What do you say to the point that was made against you by reference to E&E and the tactical filing?
Yes. The point about E&E, I say, different to this case and different to A and B, is that so far as E&E is concerned, the wife's petition was tactical, and she was not asking for her UK petition to proceed. She was asking the court to stay her petition in the event that the French petition by the husband was dismissed for some reason. So her tactical, that was found to be tactical, application was inviting the court not to apply 19.3 in the clear face that it should apply 19.3, because the proceedings issued by the husband were live and were accepted in the French court. And what the wife was asking the UK court to do was decline jurisdiction, but put my petition on ice so that I can revive it in the future. And that, of course, is a simple device that wouldn't be allowed. A matter is only stayed pending judicial confirmation as to where jurisdiction lies, and until such time as an application is made and it's brought to the court's attention, that should be dismissed. So E&E is very much dealing with a different point, but my client's application, a petition in the UK, was made at a time when she didn't have service of the Italian petition issued by the husband.
That's the one on the 4th of February 2019.
No, I'm talking about the petition that was originally
the
original
divorce
petition.
Sorry,
yes.
yeah.
My client's petition was issued on the 19th of May 16.
Yeah.
And at that time, she hadn't been served with the Italian proceedings, which had been issued by the husband on the 23rd of March 16. And so my client obviously knew the parties were distant, anticipated that there would be litigation. She sought advice, and the clear advice that is noted in the chronology was, well, if he acts in Italy, your UK application is likely to be stayed. My client's application wasn't made, that petition was not made, knowing that the husband had issued judicial separation proceedings in Italy. And that is why the issue of jurisdiction, when it came before the court in 2016, before the district judges, it continued to be stayed and adjourned over pending jurisdiction being resolved. And so certainly my client absolutely says that her petition was not tactical, and in actual fact her application made in February 19 was not tactical.
And you've explained why you say that.
Absolutely.
No. Thank you.
No, thank you very much, Mr. McGee. Mr. Amos.
2 points, please, my Lord, in reply. Excuse me. First, as to the respondent's notice, the suggestion that there is a significance in the absence of the words in Article 19.3 of its own motion. Clearly, as a matter of construction, if you are into the territory of Article 19.3, you have only got there by either Article 19.1 or 19.2, and each of those require the court to act of its own motion. So we invite you to say there's nothing in that point.
Well, what do you say to Mr. McGee's, as it were, argument of rationale for the distinction? Namely that it's obviously right for all parties affected to be given the opportunity to make submissions on whether or not proceedings should be dismissed.
Well, Lord, clearly there is more force in that, but with respect, it doesn't detract from the overall submission for the husband that the European framework is clear and certainty is its goal. And therefore my primary position that you do not need a separate application, but again with respect my secondary fallback position that in any event this aspect was brought very clearly to the court's notice at all stages, not only in front of His Honour Judge Everall, but materially for the purposes of this appeal in front of Her Honour Judge Roberts. And therefore, and this is the second point, the significance of the two written passages that I referred the court to earlier. Firstly, at supplemental bundle 212, that is the skeleton argument on behalf of the husband that your lordship looked at August 2019, and the written closing on behalf of the wife at supplemental bundle 325, which is the passage that your lordships looked at where Sally Jackson on behalf of the wife made clear that the husband had been asking throughout for dismissal of the petition. And in those circumstances, I invite your lordships to look back at the skeleton argument that Mr. McGee has submitted on this appeal, and particularly at Core Bundle page 77 and paragraph 24, where he says on behalf of the wife that she has no recollection of and does not see any reference to an application nor invitation as to the dismissal of the petition issued in England through the transcripts nor council's documents. We say with respect that there is repeated and obvious invitation, even if I cannot point to an application. The Lord, the conclusion must be on Malone and Friends' submission and the wife's case that the efficacy of Article 19.3 depends on whether the court, in this case the English court, happens to be awake and active. And in my submission, that cannot be the right basis on which to administer a European-wide system that is built on certainty. And especially at the present time, in my submission, it is of particular importance in this case, but also in the wider context, that this court in England is seen to be applying the rule of law in relation to this regulation.
It is built on certainty. I completely accept that submission. And there is nothing more certain than an application. It's a fundamental tenet of civil law. There's an application both sides know and the court knows.
My Lord, I completely accept that.
And that goes to your point about whether the court happens to be awake and active.
Well, my Lord, I completely accept the autonomous responsibility to which your Lordship is making reference, but in my submission, it does not of itself detract from the point that if the wife's case is right, there is an element of the chance of whether the English court is awake.
Thank you. Yes, is that it?
Thank you, my Lord.
Well, I've got a question, if
Sorry.
I may.
No,
So after-
no, sir. Do you have any question?
No.
Yeah.
Can we look at the rules?
Lord, of course.
The rules. Rule 727.
Lord, yes.
You have it on your machine. My Lord will have it in his book. I'm afraid Lord Justice Coulson has
I'm sure
unaccountably...
it finds a reflection in the civil procedure rules, one way or another.
I'm afraid my Lord has... I should have arranged, I wondered whether I should arrange for my Lord Justice Coulson to have a copy of the red book. I don't... Will you bear with me?
I'm very happy to.
Have you got access to Rule 727 on your machine?
Lord, I shall have it in just a moment, but I am very conscious also that it is referred to specifically by Her Honour Judge Roberts, unless I am aberrating. But if your Lordship will give me just a moment.
Thank you.
Oh, that's very kind. Thank you. Thank you. Yes, thank you very much.
So 727.2 provides that when at any... It's on page 1463 of the... Where at any time after the making of an application under this part, it appears to the court in matrimonial proceedings that under Articles 16 to 19 of the regulation, the court does not have jurisdiction to hear the application and is or may be required to stay the proceedings, the court will A, stay the proceedings, and B, fix a date for the hearing to determine the question of jurisdiction and whether there should be a further stay or other order. 3, the court must give reasons for its decision under Articles 16 to 19 of the Council regulation, and where it makes finding of fact, states such finding of fact. Doesn't the structure of the rules indicate that the procedure should... It does involve the matter being determined after a hearing, ultimately determined after a hearing?
My Lord, I can completely see the force of that argument, but in my submission it does not require it. But in any event, even if it does, you still have the husband's fallback in this case, that he brought it centrally to the stage, and it was clear in everybody's mind, including, as the wife's counsel said in her written submissions to Her Honour Judge Roberts, that over 5 days the husband's counsel had made that point exactly clear. And that was the reference that I gave your lordships at supplemental bundle 325, being Miss Jackson's written closing submissions to Judge Roberts on the 4th of December.
And Judge Roberts dealt with it at pages 15 and 16 of her judgment, as you said, it was 727.
Lord, yes.
Thank you both very much for your comprehensive submissions. We are going to reserve our judgment. It will be distributed in the usual way to the parties in draft for you to identify any typographical errors, but not to seek to re-argue any points determined in the judgment. And we would hope once you have received it, you'll be able to agree the draft order, but if there are any outstanding issues, then we will deal with them on short written submissions. So, as I say, thank you very much for your comprehensive submissions. And that brings today's hearing to a close.